એ અમારા ત્રણે આવે પ્રદીપ સરમાં જઈ નથી આવ્યો.
श्याम सुंदर दुधार किसी एजे पप्पा ये मेरे पति
श्याम सुंदर
मोहम्मद बिन समा ये में आपको
और मोहम्मद बिन समा
पर सुलेमान समा
मोहम्मद समा चार
किसी एजे वाला
हाजिरी माफी
देवीलाल भाई मीणा एल्मा मेरे को बंसीलाल मीणा
साहिब
MD Khattan, MD Bhuj, Mahida Sama, Devi Sadan, Sadan, Arti Khattan, AD Muncha, Vintage Joshi, के बायो भेजे जाएगा कि बीएन बारो बीजे जोशी मंजुला बेंसा के मुआ कीवी मानिया बीएम प्लस बुक्स
MD Bhuj,
एमडी खत्तर जीएन गढ़ी ये गढ़ी से वो इमेज भी पर चार न्याय
નહીં સર. સાહેબ હાલના જે ડિસ્કોર્ડન મૂળ ફરિયાદી એ સાહેબ ટ્રાન્સપોર્ટ પાસવો લોજિસ્ટિક ના નામે સાહેબ ટ્રાન્સપોર્ટના ધંધાથી સંકળાયેલા અને કમિશન એજન્ટ તરીકે સાહેબ એ કામ કરતા હતા. જ્યારે હાલના આરોપી છે અપેલન્ટ, એમણે સાહેબ ડિલિવરી ઓર્ડર લેતાની સાથે કેટલુંક પેમેન્ટ ટ્રાન્સપોર્ટ પાસેથી એડવાન્સ લેવામાં આવે, પછી ત્યાંથી જે રકમ મળી જાય એ બાદ કરી અને એને ચૂકવણું કરવાનું હોય. સાહેબ એ વ્યવહાર અનુસંધાને એને ચેક આપ્યો. આ ચેક અનુસંધાનેની કોઈ રકમ એને પરત કરી નહીં. એટલા માટે સાહેબ આ ચેક છે એ સાહેબ મારા ખાતામાં નાખેલ અને રિટર્ન થયું. અને એ રકમ સાહેબ અમને નહીં મળતા હાલની આ ફરિયાદ કરવામાં આવેલી છે. અને ટ્રાયલ કોર્ટમાં સાહેબ એમના તરફથી સાહેબ આ રકમ મળેલી નથી કે કોઈ પણ જાતનો સાહેબ બચાવ લેવામાં આવેલો નથી કે સાહેબ પુરવાર થયેલો નથી. એટલે ટ્રાયલ કોર્ટે સાહેબ એમને જે સજાનો સાહેબ જે હુકમ કરેલો છે એ સાહેબ યોગ્ય છે. એટલે સાહેબ ટ્રાયલ કોર્ટનો ઓર્ડર છે સાહેબ એ કાયમ કરી અપીલ રદ કરો સાહેબ મારી રજૂઆત છે. અને અપીલમાં સાહેબ લેખિત દલીલમાં જે ગ્રાઉન્ડ આપ્યા છે એ કોઈ ગ્રાઉન્ડ સાહેબ એવા નથી કે જે ટ્રાયલ કોર્ટે જજમેન્ટમાં કોઈ ભૂલ કરી હોય. Yes, yes. Much obliged.
₹40,000 ચેક કે 70,000 સાહેબ ફરિયાદીને આપી દીધેલા છે. સાહેબ આ તો 15 દિવસનો સમય આપે છે. એનામાં સાહેબ એનો દસ્તાવેજ થઈ જાય એટલે બધા પૂરેપૂરી રકમ આપી દે છે. અને રિસ્પોન્ડન્ટને એડવોકેટથી વાત કરી છે, હું આવું છું, સીન કરી નાખી વાંધો નહીં, રેટ આપો 15 દિવસ પછી, ના થતો હોય તો સાહેબ ચલાવી લઈશું. 70,000 ઓલરેડી આપી દીધા છે એમને. 70,000 ઓલરેડી આમાં આપી દીધા છે.
પૂછે બાર દુભાઈ એમાં સાહેબ ડિસેબિલિટી
નરેન્દ્ર પોપટલાલ પ્રજાપતિ, અજીતસિંહ મહેશ્વર પૂજાલા, અજીત કુમાર નિરંતર પટેલ, નિરંતર કુમાર શર્મા. તમારે નામ સરેન્ડર માટે સમય આપવા વિનંતી છે.
સેન્ટેન્સ ઉપર મેં પહેલા રજૂઆત આપને કરેલી કે સેન્ટેન્સ ઉપર અમને જ્યારે આ નિર્દેશ કરાવો કે કન્વિક્શન તો સેન્ટેન્સ ઉપર અમને આગળ લેવાનું થાય. હવે એવું છે ભાઈ કે there is we are making an application under 360 and 401 જે BNSS for probation. Now even in the appeal that against that sentence, that probation can be considered. એટલે we are doing an application. અને હા સર This is para 4. Order to release on probation of good conduct or after admonition. So there are two things. One, they say on the basis of good conduct, past record, no conviction, age. Number one, against sentence, he can be admonished. એટલે કે સાહેબ reprimand કરી શકાય, warning આપી શકાય against the sentence. If the sentence is less than 2 years, and if all other factors, that is no previous conviction, age, my whole entire conduct of in the life, so everything is required to be taken into consideration. And one under 4013, पहला साहब आप 3 जो 4013 इन अंदर में रिप्रोड्यूस करें. In any case in which a person is convicted of theft in a building, dishonest misappropriation, cheating, or any offense under Bharatiya Nyaya Samhita 20, punishable with not more than 2 years, or any offense punishable with fine only. No previous, now important है. This is number one, के punishable with not more than 2 years, a पहले criterion, or punishable with fine only. अबे Emma, what is to be considered? No previous conviction is proved against him, number one. 2, age. 3, character. 4, antecedents. Or any extenuating circumstances under which the offense was committed, instead of sentencing him to any punishment, release him after due admonition. Now please see just in the following lines. It is submitted that the Honorable Court has power to exercise the said section to release the applicant on probation of good conduct, and admonition is advised with a hint of scolding, a warning not to do something when you are cautioned or warned about some mistake which you might be just about to make, or some looming danger you are receiving an admonition. એટલે સાહેબ આપ રેપ્રિમેન્ડ કરીને વોર્નિંગ આપી છે અગેન્સ્ટ એ સેન્ટેન્સ, એડમોનિશ કરીને આપ છોડી શકો છો અગેન્સ્ટ ધ સેન્ટેન્સ. નંબર 1. નાઉ નંબર 2, હવે એના પછી નંબર 4 છે સાહેબ, આપ સાહેબ જો 3 પછી 4 order under this section may be made by any appellate court or by the High Court or the Court of Session when exercising its powers of duty. So appellate court કરી શકે છે. So at any stage this can be exercised. પછી 1. Like sir, if I believe it's and 1 sir, it is saying that when any person not under 21 years of age is convicted of an offense punishable with fine only or imprisonment for a term of 7 years or less, or when any person under 21 years of age, any woman is convicted. Sir, હું પહેલો વન વાંચું છું સર પ્લીઝ. Grateful. Great. Not punishable with death. And I would really require my lords to be with me at this juncture. I'm grateful. With death or imprisonment for life when no previous conviction is proved against the offender, if it appears to the court before which he is convicted, regard being had to the age, character or antecedents of the offender and to the circumstances in which the offense was committed, it is expedient that the offender should be released on probation of good conduct. The court may, instead of sentencing him at once to any punishment, direct that he be released on his entering into a bond or bail bond to appear and receive sentence when called upon during such period not exceeding 3 years as the court may be, the court may direct, and in the meantime keep peace and good behavior, provided that where any first offender is convicted by a magistrate of second class, not specially empowered, so and so, the magistrate of the opinion that the powers conferred by this section should be exercised, he shall record his opinion to that effect and submit the proceeding before the magistrate of first class, forwarding the accused to or taking bail of his appearance before such magistrate who shall dispose of the case in the manner provided so and so. So, my lord, I'm about 21 years, I'm 72 years old, man, my lord. One, there is a bloodless career in 1976 batch IPS officer, my lord. And I got superannuated in 2012. Having a bloodless career, then I will also I have placed certain, my lord, what I have achieved in my career. What is to be seen here is the character, age, previous conviction, antecedents, circumstances should be released on probation. So there are two things. One, 4013 says that a person taking into consideration all these factors, a person can be released after due admonition, number one, and or, I would say or, a person can be, a convict can be granted probation under 4011. Now please see, this is the probation of Offenders Act. Please see section 3. It is an act to provide for release of offenders on probation or after due admonition and for matters connected therewith. Now please see section 3, sir, of section 2. Exactly identical. When any person is found guilty of having committed an offense punishable under 379, 380 or 381 or 404 or 420. Now this is where or any offense punishable with imprisonment for not more than 2 years. So I'm 3 months minus. Or with fine, or with both, under the IPC or any other law, and no previous conviction is proved against him, and the court by which the person is found guilty of the opinion that having been regard to the circumstances of the case, including the nature of offense and the character, nature is it's a trivial matter, not summary trial case. And no previous conviction, a person is found guilty of the opinion, having regard to the circumstances, including the nature of offense, character of offender. That character I point out from my Milord series. It is expedient to do so then, notwithstanding anything contained in any other law for the time being in force, the court may, please see, instead of sentencing him to punishment or releasing him on probation of good conduct, under section 4, Kachchh साहब के instead of sentencing or probation, एक बाजूमा मुकीने release him after due admonition. So this is the first criteria of section 3 that instead of sentence and probation, releasing him on probation, બે સિવાય જે છે he can be released after due admonition. This is one. Now 4. Power of the court to release certain offenders on probation of good conduct. Now this comes again probation. When any person is found guilty of having committed an offense not punishable with death or imprisonment for life, and the court by which the person is found guilty of the opinion, having regard to the circumstances of the case, including the nature of the offense and the character of the offender, it is expedient to release him on probation of good conduct, then notwithstanding anything contained in any other law for the time being imposed, the court may, instead of sentencing him at once to any punishment, direct that he be released on his entering into a bond with or without sureties to appear and receive sentence when called upon during such period not exceeding 3 years, as the court may direct, and in the meantime to keep peace and be of good behavior, provided that the court shall not direct release of an offender unless it is satisfied that the offender or his surety can, as a fixed place of abode, regular occupation in the place over which the court exercises jurisdiction, and which the offender is likely to leave during the period for which he enters into the bond. Before making an order, the court shall take into consideration the report of the probation officer, and then if it is of the opinion, and then kindly see. So ultimately, it says that these are the conditions. If these conditions are satisfied, then in that case, I can be released. Now, please see after due admonition. Now, please see. It's just application. પછી સાહેબ હું આને મેરિટ ઉપર બતાવી દઉં. I'll try to persuade my lords that, and there is a judgment even of Gujarat High Court which says that it's a mandatory provision. That I'll point out. Justice Bedar from that. Now, please see. મારી એપ્લિકેશન પૂરી થાય એના પછી સાહેબ એને સેપરેટ એક કમ્પાઇલેશન થી આપ્યું છે. હા આના પછી જસ્ટ નાઉ પ્લીઝ સી. Joined the Indian Police Service in July 1976, allotted state of Gujarat. Served as Superintendent of Police in 4 districts: Amreli, Mehsana, Vadodara Rural and Kachchh. On deputation to the Government of India and the Cabinet Secretariat from October 1985 to October 1992. Served in Jammu and Kashmir from April 1985 to April 1989. Posted to the Embassy of India, Belgium from 1989 to 1992. On repatriation to the state government in 1992, appointed as the Additional Commissioner of Police Crime, Ahmedabad City. In May 1993, as DIG operation in charge of the anti-terrorist squad to deal with the militancy. Promoted in November in 1995 as Special Inspector General of Police and appointed as the Secretary in the Home Department, Government of India, Government of Gujarat. Appointed as Commissioner, Prohibition and Excise, Gujarat State 1997-98. Served as the Commissioner of Police, Rajkot City, Vadodara City and Surat City from 1998 to 2001. During the communal riots in Gujarat, served as a Special Inspector General of Police, Ahmedabad Range 2001-3. On the promotion to the rank of Additional Director General of Police, appointed to the head of the state CID crime, Gujarat State 2003-2005. Served as the Additional Director General of Police Training 2005 to 2008. Served as a member of UN panel of experts for Sudan to monitor Security Council resolutions 2009. On central deputation to the Bureau of Police Research and Development, Ministry of Home Affairs, New Delhi as Additional Director General and then Director General 2011-2012. On superannuation, appointed Advisor, Ministry of Home Affairs, Government of India 13-14. United Nations Development Program, International Consultant, Law and Order, Nepal 2015. International Consultant, Complainant, as a UN deputation state. Complainant Mechanism, Afghanistan 2016. International Consultant Complaint Mechanism Afghanistan 2018, Anti-Corruption Judiciary Experts Solomon Islands 2019, Experts Indian Police Foundation Project for Internal Police Reforms. સાહેબ આ credentials છે just એના પછી સાહેબ આપ સાહેબ જો now decorations. Now please see, awarded President's Police Medal for Distinguished Service on Independence Day 2001, awarded Independence Day Medal 1997, awarded Indian Police Medal for Meritorious Service on Republic Day 1994. Awarded Police Special Duties Medal for Service in Jammu and Kashmir 1986 to 1989. Now, sir, these are all awarded by the President of India. Please see Distinguished Service Medal, then Special Duty Medal Jammu and Kashmir, Meritorious Service Medal, Independence Day Medal. Now the next, please see the next page. Next page. એના પછી श्री के.एन. शर्मा, पुलिस महानिरीक्षक गुजरात। मैं भारत का राष्ट्रपति के.आर. नारायणन आपकी विशिष्ट सेवा को मान्यता देते हुए आपको राष्ट्रपति का विशिष्ट सेवा मेडल प्रदान करता हूँ। के.आर. नारायणन, राष्ट्रपति, नई दिल्ली, 5/8/2008। Now please see the appreciations which I have got during my service. This is 1980 onwards. It is not one day affair. This is to appreciate the services to your office and men rendered during the last general elections of Lok Sabha. I hope you will acquit yourself in future whenever so and so, reference so and so. Then please see R.N. Bhattacharya, the next page. The IG of Police congratulates you for displaying high sense of duty and courage in participating in an operation for arrest of accused person in Bagasra, CR number so and so, as a result of which 2 notorious criminals wanted since 1979 were arrested. R.N. Bhattacharya. Then please see the next one. CP Singh, please refer to your wireless message number so and so 1983 regarding apprehension of a Park National so and so, the work done by you and the district police is unearthing a dangerous ring of trans-border criminals, smugglers, and spies is appreciated. This is what I have achieved. Then next page. This is by R. Balakrishna, the cabinet secretary of the government of India. My dear Sharma, this is 1988. I have just gone through the half-yearly review of SB's performance for the period ending 31st January 87. I would like to convey my appreciation of the impressive all-round improvement brought by you and your staff in SB's output. Particularly gratifying is the fact that your SB has been able to answer more than 55% of the queries raised by the PMI branch. Well done. Wishing you and your team good hunting in current year. This is IB. Then in recently held test on subject to departmental proceeding, you have obtained 85% marks. Secretary has asked me to convey his appreciation to you for excellent performance. Now next page. Office of the Director General and Inspector General Police, Gujarat State, Mr. Ashok Tandon. It gives me great pleasure in placing on record the strenuous efforts that you have made in working out the information which resulted in the arrest of 4 notorious criminals who were involved in Udhav carnage and shootouts in Ahmedabad. This is that infamous Milord પેલો સાહેબ કહેવાય છે ને પેલું રાધિકા જીમખાના કેસ. that infamous case where indiscriminate firing rahi thi, that the late Latif gang had made indiscriminate firing in that Radhika Gymkhana. There are a number of judgments on this, Radhika Gymkhana. They were all convicted till the Supreme Court. That was investigated by me. Please see, involved in Odhav carnage as well as other shootouts of Ahmedabad city. The information was developed and worked as a sequel to the arrest of one Aslam who found gambling in so-and-so in Kalapur Tower, along with servants of Latif, Viz, Nazir and Latif, three gangsters, Iqbal, Jabbar Khan Pathan, Ashraf Khan, Ajab Khan Pathan, Ahmad Hussain, Wali Muhammad Saeed, were apprehended from Naib Mohala near Panchkua Gate. Maqsood Fateh Muhammad Sheikh, who was wanted in Odhav carnage and other three grave offences, was also arrested from Shafi Mohalla near Bhanderi Pol. In planning this strategy, you were assisted by PI, PN Baro, UPC, Nizamuddin, so-and-so. In fact, Nizamuddin knew Aslam, having been connected to the notorious activities of Latif and his gangsters, and PI Shri Baro could work out this information successfully under your able leadership. Please accept my congratulations for doing an excellent piece of work. Please keep it up and make all efforts to arrest the remaining dangerous criminals of Latif gang. Also, a copy of this letter we kept in e-roll of PI Shri Barot, and suitable entry we made in the ACR of Shri Barot to be made when the annual report is written, and likewise action is to be taken in the service book of UPC Nizamuddin. I presume that Shri PI Barot and Nizamuddin have already been suitably rewarded by CP, this being within his competence. Then next, Sarup Singh from Raj Bhavan, Governor of Gujarat. I am happy that the President of India has been pleased to award police medal to you. In recognition of your meritorious service, I offer you my congratulations. I am confident that in future you will win still greater honors for your devoted and distinguished service to the nation. So it is not confined to the state. Now, Home Department, Additional Chief Secretary, government is exceedingly pleased to learn about and to convey its pride and appreciation for professional skill, initiative, and dedication shown by you in nabbing Usman Ghani Noor Muhammad Merchant, alias Munna Abdullah, a close accomplice of Mahmoud Ibrahim, in the conspiracy resulting in bomb blast in Bombay in March 1993. Please see my work, my lords. Please accept my congratulations for this remarkable achievement which has brought laurels for Gujarat Police on a national level. Maintain the spirit and continue to perform yet better. This is what my credentials are. Now, this is Office of the Director General of Police, Gujarat State, 94. Here with a token of appreciation for all strenuous efforts made by you to make inter-region coordination meeting of Baroda so-and-so grand success. I am aware that there are many more who work with you in this cause. I recommend so-and-so. Then next, 15/8/95. Government is extremely pleased to place on record its appreciation for the professional skills, initiative, and dedication to duty shown by you in nabbing Muhammad Salim Mir Muhammad alias Kutta, who is involved in a heinous crime affecting national security. Please accept my congratulations for this commendable task, which has earned the Gujarat Police a name at a national level. I expect you to maintain the spirit and to perform yet better in meeting such challenges in future. Then SL Verma, Additional Chief Secretary. Government is extremely pleased. So appreciation for professional skill, dedication to the duty shown by you, Nabi Abdul Qayyum, Haji Rafiq, Usman Musa Lama, who are involved in heinous crime affecting national security. Please accept my congratulations for this commendable task, which has earned the Gujarat Police a name at national level. I expect to maintain the spirit and so and so. Now next, 1996. Again, this is Principal Secretary. Government is pleased to place on record the appreciation professional skill, so and so, to duty shown by you. Now, please see, this is very important. A dreaded criminal. Sir, Adharik Channu, sir, please. Duty shown by you in nabbing Abdul Latif Abdul Wahab Sheikh, who is involved in major crimes affecting national security in your capacity as DIG ATS. Please accept my congratulations on your commendable performance, which has earned Gujarat Police a name at national level. I extend my greetings and good wishes to you to expect that you will maintain spirit and determination to excel in meeting such challenges. Then 31 and 190. I write this letter, SN Sinha, Director General of Police, to convey my deep appreciation for the excellent performance of ATS under your captaincy. If ATS has last few years been resplendent in its achievement, it is because of meticulously planned operations you conducted against terrorists, anti-national, anti-social elements, smugglers. This is what I am facing today. And in life, duly collecting required intelligence for the purpose. The rapport established by you with CBI and with Bombay Police, apart from the other state police forces, was of high order, playing a significant role in your plans of success, honoring your plans of success. It is not for nothing that ATS has in public mind acquired its own halo of glory and earned a top-ranking niche for Gujarat Police in the committee of all state police forces. I am sure you will take Gujarat Police to the scale further heights, and I wish you all the best. Now, next, again, DGPs. Now, this goes on and on and on. It doesn't stop here, my lords. It goes on and it is till 99, 2001, then we got 2001, then 2004, and then 2005. And 2006, I retired in 2012. There is a certificate after that, please see. Our certificate says that Bureau of Police Research and Development. Reason for grant of commendation certificate in recognition of outstanding performance of duties and specific assigned tasks during BPR&D investiture ceremony and foundation day of 2011. Now the second one. This is certificate of appreciation by United Nations Development Program expresses gratitude and appreciation to Kuldeep Sharma in recognition of his great service to United Nations Development Program NPD project in capacity of international consultant compliant mechanism 2018 Kabul, Afghanistan. So this is what I have done. This is my character. This is what I have given my blood to this country. And then please see the other document. I don't want to read this in the open court. It would not be appropriate for me, but my lords may kindly read it carefully. એના પછી એક order, એક judgment છે સાહેબ. એના just પછી there is a dossier. Please see. Judgment પછી. Now please read this. એના column number 21 માં સાહેબ. Please see this. These are the credentials. Everything anti-national. Here I have given my life to the nation. This is not what I am saying. I could have placed this on record on the first occasion also, whether this would not appeal to my nation. And what today I am asking? I am asking something which is provided to me in law. Yes, kindly, just a glance at it. પછી એના પછી બીજું ચાલુ થાય છે એના જસ્ટ પછી આ પહેલું છે પછી બીજી આ રીતે આ રીતે six goals. Now today what I may read to myself that 255 of the CRPC, actually 360s है क्योंकि it is BNS. Though the procedural law are retrospective, but once 401 provides that if you are convicted under BNS, then BNSS 401. Even 360 is pari materia, same છે સાહેબ 360 જે છે એ 1 and 3 it's the same CRPC. एक बिल्कुल word to word same है, nothing is changed. 360 subsection 1 and section 3. 1 is for probation and 3 is for admonition. one judgment of Gujarat High Court says that that this is a mandatory provision, and this I am going on the Supreme Court. This is that infamous case of a former Director General of Police, KPS Gill of Punjab. Two 2005 6 SSC 161. Now please see page 163. The last line. The Chief Judicial Magistrate later framed the charges, and after a full-fledged trial, the accused was found guilty of the offence punishable under 354/509. He was sentenced to undergo a period of 3 months and pay a fine of 500 for the offences under 354 and for offences of 509. Punishment of simple imprisonment for a period of 2 months and a fine of 200. In the appeal preferred by the accused, now this is important. In the appeal preferred by the accused, like I am before my lords today, the session judge confirmed the conviction. Sir, 164 ऊपर चलता है. Sir, आज है ये. Sir, 163 no last line आप sir. I am so sorry. I lost my 163 की last line. The Chief Judicial. The Chief Judicial later framed the charges. अबे 164 ऊपर है. After a full-fledged trial and the accused was found guilty of the offence punishable under 354/509, he was sentenced to undergo 3 months, 354 and 509 2 months. Now this is important. In the appeal preferred by the accused, the sessions judge confirmed the conviction. This is what has happened, but altered the sentence, and the accused was directed to be released on probation in lieu of custodial sentence. The fine was enhanced to ₹50,000 with a further direction to pay half of it to the complainant. The accused challenged the same in the revision before the High Court. The High Court did not interfere with the conviction and the accused under 354/509. However, the fine was enhanced to 2 lakhs and the entire amount was directed to be paid to the prosecutrix. An amount of 25,000 was directed to be paid so and so. And then please see para 165 Para 5 of 165, the appeal preferred by the complainant. Now complainant went into appeal. Senior counsel so and so content that crimes against women are on the rise and the court should have dealt with the matter severely and accused should not have been released on probation. The incident is of 1988. Now this is important. If I am correct, my lords on the very first day pointed out that it will go by the date of incident, that how old is the case. It will not go by the date on which the appeal is filed. So this is 1984. And this was 1988, and this the court is saying in the year 2005. The incident is happened in 1988. Despite the accused holding a high position in the state police, the various courts found him guilty of the offence punishable at 354 and 509, and that by itself is setting a model for others and would enhance the faith in judicial system. The accused had completed the period of probation. There is no occasion for any complaints, and so at this juncture, we do not think it just and proper to resort to another punishment in the other view preferred by the complaint against so and so without any substance, and the same is dismissed accordingly. Now there are 2 more judgments. I am getting the copy. एक चीज है This is 2007 2 GLR 1295. Rajiv Mangilal Jain versus State of Gujarat. Justice D.H. Wajir. Decided on 21/12/2011. The other one is 1984 2 GLR 1470. Gopal Bhai Parshottam Das Chauhan versus State of Gujarat, decided on 13/3/1984. It says that 360 and 361 are mandatory procedure prescribed under 248. 2 is of mandatory. It is I just am getting a copy of it. May I just in the meantime read a few lines? We said 248 જે છે CRPC એ જો આપ સાહેબ જોશો તો 248(2) it says where in any case under this chapter, this is warrant trial, 248 plus 255(2) applies to me. એ બી આમાં ડિસ્કસ કર્યું છે. So where in any case under this chapter the magistrate finds the accused guilty but does not proceed in accordance with the provisions of 325 and 360, he shall, after hearing the accused on the question of sentence, pass sentence upon him accordingly. This provision clearly provides that after the magistrate found the accused guilty but does not proceed in accordance with 360, then he shall, after hearing the accused on the question of sentence, pass the sentence upon him. Now it says that even 255 provides for that. So 255(2) in a summary trials may not 255(2), it is to be read with 360 361. CRPC 360 361 and this Rajiv Mangilal under revision the High Court granted the benefit of probation. So today, time before my lords, my appeal is dismissed. The conviction of 3 months, I have not seen the judgment of my lord. Copy of I was convicted by the trial court to 342 again. That conviction is upheld. Now the conviction can be gone into. Now once my lords I said that conviction is upheld, now there is no argument here. It is only before any other appellate court, revisional court it can be. But my lords are having all lord authority power to decide on my 360 subsection 1 and subsection 3 application which I have made. My lords have seen my credentials as a police officer since 1976. Each day I have served my nation. This is not my lord. It is all said by my lord, my superiors, the government of Gujarat, the government of India. And under 360 or 401, what is to be seen today is my character, my credentials, my age. I'm 72 years old man. Once I'm sent to jail, but what benefit it would serve to anyone? And in a case of 1984, today I filed this application pointing out that I very well fall within those criteria. And the benefit of admonition, that is 401 subsection 3 or 360 subsection 3 of CRPC, or 401 subsection 1, that is probation. So my prayer is in alternative. If this honorable court may please see the prayer. The prayer is in alternate. Please to release the appellant after due admonition under section 4013 of BNSS, read with section 3 of Probation of Offenders Act instead of being sentenced. Your Lordship may please to release the appellant on probation of good behavior under 401 of BNSS, read with section 4 of the Offenders, Probation of Offenders. I'm saying either or. So admonition, this is the first part. I very well fall within that criteria. Or if my lords are not satisfied with this, then again 401 1. Read with section 4 of the provision. And my lord, till such an application, I have moved another application. I was just, my lord, trying to persuade my lords that this is what prima facie case I have for 360 and 401. Now, I have also prayed by way of an application that till this application is decided, the same order, my lord, be continued in my favor by this honorable. On the same time, there are a lot many things which I could have said, but I have to restrain myself as a counsel and a responsible member of the bar. Yes, sir. With all due respect, I humbly submit that at least till the time this application gets decided by me, this order passed by my lords today be stayed. And who my lords are deciding my application. Whenever it is up to my lords. So it's my lord, I can my lord point out number of orders. Number of places the court has granted exemption from surrender. I am only on this application. Once my lord decides this application in my favor, then nothing is required. And I am sure, my lord, these credentials may is a big word today, my lord, but may lord appeal to my lord's conscience. And on one hand, there are the credentials, my credentials, on the other hand, I pointed out the credentials, my lord. I'm just mincing words, I'm not, but my lords could understand what I am saying. So if a person who has served the nation for a whole life with all these credentials, Lord, please, 3 months. It's 3 months. I can understand it had been 3 years, 1 year. It's 3 months more. So at least this benefit, whatever happened is happened. This may be having a far-reaching impact on me. Once I asked that why you were doing your duty so diligently and what you are getting out of it. The answer was, with all humility I am saying, that it was and it is the trust in judicial system. So I was able to deal with my superiors, my subordinates, my whole political system in my own way, in accordance with law. So today what I am submitting before my lords, that nothing, this is a provision which is not mandatory. My lords may consider it. I am now without saying even Mr. Gadvi will submit for his plan. He is having without his own credentials. He is a police officer. He has remained police officer. He has worked in this district for such long years. But at least at this juncture, Khalid Sahib, aap said, conscious, I am just trying to appeal to my lord's conscience. That conscience is not conscious of a person, it's a judicial conscience. I have my own ways, means, it may be challenged, it may not be challenged, that's a different thing. But Sahib, Ajay, today, I'm saying there is a provision, I fall within those criteria. Please grant me at least that relief at the age of 72. And this case has brought irreparable harm to me. Social, legal, there are a number of implications. Today I am just appealing to my Lord's judicial conscience that please consider this request. Lord, grant me an order under 4013 in the alternative 4011. Instead of sentencing me, the courts have said so, my lord. It is still the Supreme Court. In an identical case, there the facts were bad. The facts were that, my lord, it was 354 with a lady IAS officer in a party. Here, the facts are better, my lord. I am honestly, my lord, humbly, with all due respect, appealing to my Lord's judicial council that my lords may kindly exercise the power of 316, the probation of offenders act so 3 or 4. My lord, one, instead of sentencing, an admonition to probation. Therefore, on the very first day when I completed the appeal, I requested my lords that please hear me on sentence if at all my lords want to an opinion that it's a case of conviction.
I end up the argument of my learned civil counsel. As far as my clients are concerned, sir, he has served in the police department for 35 years, from PSI to the DYS. As far as so many cases of smuggling, anti-social elements against the nation, he has conducted the investigations. All this service he has rendered for the 35 years to the state government of Gujarat. Today, the question before this honorable court, I am in the police force, whether I am entitled this benefit or not. The person who are the layman, if he is entitled probation, sir, as a presiding judge of this honorable court with great experience, your honor may be granted this benefit to others. So I, with a folded hand, pray before this court that there is no other serious offense against me. If the benefit which are entitled by the law, that cannot be rejected on the ground that the person is the police force. Whatever the benefit which are entitled under the law, sir, that I am entitled. Whatever the judgment of the Honorable High Court and with the Supreme Court that is required to be followed. We can't distinguish, sir, that these are not applicable to the particular case. It is my humble submission before the with all that and before the Honorable Court that these all are the judgment ratio laid down by the Supreme Court. In this type of cases, benefit may be granted. So I appeal to the judicial conscience of this honorable court to grant, sir, relief of the probation. Second, as per the time may be granted and the order of conviction may be stayed till this application may be decided, sir. Please.
Okay. Remember, this is in CRA, Criminal Division Authority. Consider reduces that para 2, my lord, if 1 year punishment, para 2 last 3 lines. Counsel that the trial court as well as the appellate court has failed to consider those relevant factors and about after about 17 years of the offense, the applicant is facing imprisonment for his first offense, as he was acquitted of the charges of the offense in the 409-420. Then 4, it clearly appears from the judgment of the trial court that the appellate court, that both the courts had failed to record the special reason for not granting benefit of provision. for releasing the convicts on probation despite presence of the relevant factors of young age of the convict, absence of any bad antecedents of the offender, and failed to consider the circumstances in which offence was committed. Therefore, in short, it appears that the subordinate courts have failed to exercise discretion and jurisdiction vested in them, requiring appropriate order by this court under Rule 4 of 360. Therefore, in short, it appears that subordinate courts have failed to exercise the discretion and jurisdiction vested in them, requiring appropriate order by this court under subsection 4 of 360. The facts of the applicant having fully refunded the amount to the lender, his being of young age of 25, his record of no previous conviction are not in dispute, having regard to the milieu in which a young partly handicapped person like a person accepts employment in the form of an agency and deals with cash. The act of even temporary misappropriation cannot be condoned, but can certainly be considered in the larger perspective, including regard to the principles and ideology underlying 360. The applicant could have been and ought to have been granted the benefit of being released on probation on executing a bond for good conduct rather than being consigned to an overcrowded jail. And we mark this. Therefore, in the peculiar facts of the case, the applicant is partly allowed. The impute order of conviction is suspended to the extent that the sentence of rigorous imprisonment for 1 year is ordered to remain in abeyance on the condition. This is exactly what I am trying to say. That let this sentence be kept in abeyance. And my lord, this is in criminal revision. So, and as I pointed out, 360 के 4014 it provides that at an appellate stage, revisional stage, कोई भी stage ऊपर साहब, आप साहब benefit आप ही शकते. This is one. The other judgment which I have given. It explains para 7, para 6 para 6 of Rajiv Mahida. No, sorry, Gopal. I had an occasion to consider this aspect, para 6. In case of Lakshman Singh versus Swanswan Criminal Revision Commission, in that case, the rule was issued by DP Desai jail. We came to the conclusion that there was no merit in the plea, as there was concurrent findings of bias based on believable evidence. But a ground was urged before him as to the legality of the order of sentence. It was considered by him that good ground needed. Examination gave provisions of 240 years. He therefore admitted that the revision petition on question of legality or order of sentence only. Thereafter, when the matter came up for final hearing, it was specially observed that considering the provisions of 248(2), that this section requires that first of all the magistrate has to apply his mind whether the provisions of 360 are to be brought into action. If not, then he has to make up his mind. For special, he shall record the judgment special reasons for not done so. Therefore, in such case, difficulty will be rights. And then, Lord, 255 is also discussed, and it says that is so and so to the extent matters remanded, remand for only for that probation of offenders act over, the matter was ultimately remanded. You just consider this. But I am saying the first judgment we say even at the stage of revision before the High Court granted probation. So I am saying the first prayer is to admonition against sentence. The second prayer is probation.
Counselor argument કરી argument અસફળ tenable નથી જેટલા પણ જજમેન્ટ
પ્રોબેશન ઓફેન્ડર એક્ટ ની જોગવાઈ PNSS ની જોગવાઈ ની જેટલી પણ વ્યાખ્યાઓ અથવા અર્થઘટન જજમેન્ટો અને ચોપડીમાંથી વાંચી બતાવે કે તમામની અંદર છે આરોપીઓએ કન્વેક્શન ને ચેલેન્જ કરેલો નહોતો અને બિફોર જજમેન્ટ પ્રોબેશન ની માંગણી કરેલી હતી. એવા સંજોગોમાં જ્યારે કન્વેક્શન ચેલેન્જ થયેલો નહોતો અને પ્રોબેશન ની માંગણી કરી ત્યારે કયા સંજોગોમાં પ્રોબેશન આપી શકાય અને કયા સંજોગોમાં પ્રોબેશન માટે હકદાર બને છે અને કયા સંજોગોમાં પ્રોબેશન માટે મેન્ડેટરી પ્રોવિઝન છે એની જોગવાઈ છે. હાલના કેસમાં સર જોવામાં આવે તો અપીલ નંબર 40/2025 કુલદીપ શર્મા એની અંદર સર આજે જજમેન્ટ પ્રોનાઉન્સ થયો એ જજમેન્ટની અંદર આરોપી જે છે એના સામેની અપીલ ડિસમિસ થઈ. આરોપી પ્રેઝન્ટ નથી એટલે આરોપી સામે સર વોરંટ ઇસ્યુ કરવામાં આવ્યો. જ્યારે આરોપી સામે વોરંટ ઇસ્યુ થઈ ગયેલો હોય એવા સંજોગોની અંદર આરોપી વતી પ્રોબેશન માંગણી કરતી એપ્લિકેશન ફાઇલ થઈ શકે અને મંજૂર થઈ શકે. તો અત્યાર સુધીના જેટલા પણ સાઇટેશનો આજે પ્રોબેશન ઓફેન્ડર એક્ટની એપ્લિકેશન સાથે જે રજૂ કરવામાં આવ્યા એની અંદરથી ક્યાંય બતાવી શકવામાં આવેલું નથી. તેમણે એક જજમેન્ટ રજૂ કરી અથવા તો જજમેન્ટના ફેક્ટ વાંચ્યા કે સેશન્સ કોર્ટે અપીલની અંદર જે છે એ પ્રોબેશન નો લાભ આપેલો અને પછી હાઈકોર્ટની અંદર ચેલેન્જ થયેલો અને એને હાઈકોર્ટે જે છે કન્ફર્મ રાખેલો એટલે કે ઇન્ટરફેરન્સ કરેલો નહીં. એ જજમેન્ટમાં સર આરોપીનો સામે જે એપેલન્ટ કોર્ટે જે અપીલમાં હુકમ કર્યો એની અંદર સજા ભોગવવાની જગ્યાએ સજાની સાથે સાથે પ્રોબેશનનો હુકમ કરેલો અને એને સર ચેલેન્જ કરેલો. હાલના કેસમાં સર નથી નીચેની કોર્ટ સમક્ષ આરોપી જે છે એને એપ્લિકેશન પ્રોબેશન ઓફેન્ડર એક્ટ તળે ફાઇલ કરેલી. હાલના કેસમાં સર મેરિટ ઉપર આર્ગ્યુમેન્ટ કરતી વખતે એમણે કોઈ એવી એપ્લિકેશન ફાઇલ કરેલી હોય કે અમને સર પ્રોબેશન ઓફેન્ડર એક્ટનો લાભ આપવામાં આવે, અમે કન્વેક્શનને ચેલેન્જ કરતા નથી, એવી કોઈ અરજી બિફોર જજમેન્ટ નામદાર કોર્ટ સમક્ષ આવેલી નથી. એટલે પ્રોબેશન ઓફેન્ડર એક્ટની જે એપ્લિકેશન અથવા તો પ્રોબેશન ઓફેન્ડર એક્ટનો જે લો છે એ પર્ટિક્યુલર કેસમાં સર હાલના સંજોગોમાં લાગુ પડતો નથી. જ્યારે આરોપી સામે વોરંટ ઇસ્યુ છે, આરોપી નામદાર કોર્ટ સમક્ષ હાજર નથી, એવા સંજોગોમાં પ્રોબેશન ઓફેન્ડર એક્ટની સેક્શન 3, સેક્શન 4, BNS ની સેક્શન 401 આની અંદર સર આરોપી વોરંટ ઉપર હોય અને આરોપી વતી એપ્લિકેશન ફાઇલ થાય પ્રોબેશન ઓફેન્ડર એક્ટની અને એ ગ્રાન્ટ કરી શકાય એવો સાહેબ કોઈ લો અથવા તો એવો કોઈ જજમેન્ટ બતાવ્યો નથી. માત્ર એટલી આર્ગ્યુમેન્ટ હતી કે પ્રોબેશન ઓફેન્ડર એક્ટ જે છે એ ક્યારે લાગુ પાડી શકાય, કેટલી સજા માટે લાગુ પાડી શકાય, એ તો સેટલ લો છે, એમાં કોઈ સાહેબ તકરાર હોઈ શકે નહીં. એટલે હાલના કેસમાં સાહેબ જે છે એ સીધે સીધો લાગુ પડતો નથી. બીજી જે સાહેબ ભાવનાત્મક દલીલ થઈ કે આરોપી જે છે એ પોલીસ ઓફિસર હતા અને એટલી આને સારી કામગીરી કરેલી છે એટલે આવા સંજોગોમાં સાહેબ જે છે એમની સામે સાહેબ રહેમ દ્રષ્ટિ રાખવામાં આવે અને એમને સાહેબ જે છે એ લાભ આપવામાં આવે. સાહેબ એમના જ કેસમાં 137/1992 જે છે એની અંદર સાહેબ અહીંયાની કોર્ટે જે હુકમ કરેલો છે એ હુકમના સાહેબ સેન્ટેન્સ છે કે રામન રાઘવન જેવો હત્યારો હોય કે સુપીરિયર પોલીસ ઓફિસર કાયદાની મર્યાદાની અંદર જે માણસ ગુનો કરતો હોય અને કોર્ટ સમક્ષ એવી હકીકતો સ્પષ્ટ થતી હોય કે આ ગુનો છે તો તેવા સંજોગોમાં સાહેબ એને લાભ મળતો નથી. આરોપીની સાહેબ એજ જે છે એ 72 વર્ષની છે એવો એમની એક રજૂઆત હતી. 72 વર્ષની જે એજ છે એ એજ સાહેબ સિસ્ટમના કારણે થઈ હોય, ફરિયાદ પક્ષના વલણના કારણે થઈ હોય ને એમની વાત હોય તો ઠીક છે. 1984 થી કરી અને 2025 સુધી જેટલી પણ ટ્રાયલ ડિલે થઈ છે as per conduct of the accused. આ સંજોગોમાં સર જે ડિલે નો ગ્રાઉન્ડ છે, એજ નો ગ્રાઉન્ડ છે, એ પણ હાલે ટેનેબલ થતો નથી. રહી વાત એમની સ્ટે ની એપ્લિકેશન ની વાત સર, ટ્રાયલ કોર્ટ થી કન્વેક્શન થઈ અને એપેલેન્ટ કોર્ટમાં જાતી વખતે સજાના જે પ્રોવિઝનો છે એને ધ્યાને લઈ અને નીચેની કોર્ટ જે છે એ સ્ટે કરે અને એપેલેન્ટ કોર્ટ સુધી જવાની જે છે એ અમુક સજા જોગવાઈ સુધી પ્રોવિઝન છે. એપેલેન્ટ કોર્ટ ટુ રિવિઝનલ કોર્ટ જવા માટે થઈ અને આરોપીને કોઈ સ્ટે આપવામાં આવતો હોય એવો કોઈ પ્રોવિઝન નથી. કારણ કે એપેલેન્ટ કોર્ટ ટુ રિવિઝનલ કોર્ટ, કારણ કે જેટલા પણ પ્રોવિઝન છે સ્ટેના એ એપેલેન્ટ ટ્રાયલ ટુ એપેલેન્ટ છે, એપેલેન્ટ ટુ રિવિઝનલ કોર્ટ નથી. આ સંજોગો જોવામાં આવે આજના સાહેબ અપીલ નંબર 40 અને 41 જોવામાં આવે. 41 માં સાહેબ વોરંટ ઇસ્યુ થયેલો છે એટલે કોઈ દલીલ જે છે એ લાગુ પડતી નથી. 41 ની અંદર સાહેબ જે છે એ સાહેબ આરોપીને સાહેબ જે છે એ સજા ભોગવવાનો હુકમ કરેલો છે. એટલે જ્યારે સાહેબ એ વન ટાઈમ પાસ ઓફ ધ હુકમ, એક વખત જ્યારે હુકમ થઈ ચૂકેલો છે એના પહેલા કોઈ એપ્લિકેશન નથી તો સેમ એપ્લિકેશન પાછળથી ફાઇલ થઈ શકે નહીં. એટલે સાહેબ કાયદાના પ્રિસ્ક્રાઇબમાં બંને એપ્લિકેશનો જે છે એ ચાલવા પાત્ર બનતી ન હોય. એમના તરફે જે સાઇટેશનો રજૂ થયા એ સાઇટેશનો સીધા હાલના કેસના મેરિટ સાથે ટચ કરતા હોય એ પ્રકારના નથી અને આને સાહેબ લાગુ પડતા હોય એવા નથી. આરોપી તરફે આરોપીની જે સાહેબ રજૂઆતો કરવામાં આવી એના કેરિયર વિશે તો સાહેબ ગમે એટલો ઉપર કેરિયર ધરાવતો માણસ હોય એને સાહેબ ગુનો કરવાની સાહેબ જે છે પરવાનગી આપી શકાય નહીં. નહીતર ગમે એટલો હોદ્દાવાળો સાહેબ ગમે તે માણસ ક્રાઇમ કરી અને પછી હોદ્દાના ઓઠા નીચે સાહેબ ક્રાઇમને સંતાડવાનો પ્રયાસ કરશે. આ સંજોગોને ધ્યાને લઈ બંને એપ્લિકેશનો સાહેબ બંને આરોપીની મેન્ટેનેબલ બનતી ન હોય સાહેબ બંને એપ્લિકેશનો પોસ્ટ સાથે રિજેક્ટ કરવા વિનંતી છે.
અલગ છે સાહેબ થોડી. સાહેબ 2012 થી ટ્રાયલ ચાલે છે ત્યારે પણ ગેરહાજર રહ્યા હોઈએ ટ્રાયલમાં અવરોધ ઉભો કર્યો હોય એવું નથી સાહેબ. નામદાર નીચેની અદાલતે જયારે કન્વિક્શન કર્યું ત્યારે પણ હાજર થયેલા અપીલ દાખલ કરીને જામીન મુક્ત થયેલ છે. જયારે અમારી અપીલ નામંજૂર થઈ છે તો સરેન્ડર થવા માટેનો સમય સાહેબ અમે હાઈકોર્ટમાં સાહેબ વકીલ રોકવા માટે પણ આર્થિક વ્યવસ્થા કરવી પડે તેવી પરિસ્થિતિ સાહેબ છે. નિવૃત્ત છે એટલા માટે અને ઘરમાં પણ સાહેબ છોકરાઓની ઘરવાળીની સાહેબ વ્યવસ્થા ખાતા ખોરાકીની પણ કરવી પડે એવી પરિસ્થિતિ. જો અમારા જેલમાં ગયા પછી સાહેબ પેન્શન પણ તિજોરીમાંથી નહીં મળે સાહેબ અમારે ઘરવાળીને. તેથી સાહેબ સરેન્ડર થવા માટે સાહેબ 15 દિવસનો સમય આપવા માટે નમ્ર વિનંતી છે. અને અગાઉ પણ સાહેબ અગોતરા જામીન ઉપર મુક્ત થયેલા હતા શરૂઆતમાં પણ નામદાર કોર્ટે અગોતરા જામીન ઉપર મુક્ત કરેલા હતા. તે રીતે પણ સાહેબ અમને હાજર થવા માટે સાહેબ 15 દિવસ આપવા વિનંતી છે. નથી તમે મારા બોલ છે. મેં કીધું સર એમનામાં તો કઈ બોલ્યા નથી. તમે મારા બોલશો
એમનામાં મને લાગુ નથી પડતું ને ઇન્ફેક્ટેડ પાર્ટી કરી નાખી દલીલ. આમાં સાહેબ જે ટાઈમ માંગ્યો છે ને એનો જે સાહેબ કારણો છે એ સાહેબ વ્યાજબી નથી. એક તો સાહેબ અન્ય કુટુંબમાં બીજા પુત્રો એના માણસો છે, સારા હોદ્દા ઉપરથી રિટાયર થયેલા છે એટલે જે આર્થિક ની વાત છે એ સાહેબ યોગ્ય નથી. સાહેબ સમય જે માંગ્યો છે એની જે માંગણી કરી છે સરેન્ડર થવાની એ સાહેબ રદ કરવા વિનંતી.
Please.